Hello, my name is Richard Barid, and I'm one of the founding attorneys here at Smith Barid LLC, and I'm an estate planning and elder law attorney. One question I get frequently is, what's the difference between estate planning and elder law planning? And the fact of the matter is, they have a lot of similarities, but there are some important key differences, and we want to talk about those today so there's no confusion. Estate planning takes many forms, but one of the most common is planning for a person putting together a will, usually that and maybe a power of attorney, a healthcare directive, some basic planning to set in line and set in motion what sort of plan a person wants in place when they are incapacitated and certainly when they pass away. It's a way to make things easier both for yourself and for your loved ones who may come along behind you. Elder law planning can be a bit more complex depending on the situation. Generally, elder law planning for us at our firm means helping families find ways to pay for long-term care. In the state of Georgia and in many states in the country, there are basically 3 ways to pay for long-term care. And here we're talking about in-home care, assisted living, memory care, and even nursing home care. One of those ways, of course, is private pay, and you may be familiar with that if you've had a loved one who needs long-term care. Usually the family starts out using the person's assets and simply writing checks, right? Paying for the kind of care the person needs on a day-to-day, week-to-week, and month-to-month basis. But with costs always going upward, regardless of what inflation is doing in the regular economy, usually in the world of nursing homes, assisted living, and even in-home care, those costs tend to go up almost no matter what the rest of the economy is doing. So it's important to know that long-term care, especially in the form of nursing home care, can cost a family anywhere from $6,000 to $8,000 per month in most places, in some places even more. So how are we going to pay for that? Most families, when they hear they're going to have a bill every month to take care of mom or dad that's $6,000, $7,000, $8,000, they're at a loss. Most of us couldn't carry that kind of financial weight month to month for very long. So private pay may be a good way to start. It may be the way you have to start, but it's generally not the way to pay for long-term care over the long term. Another way to pay is with long-term care insurance. Many of you have spoken with financial advisors before and talked to them about long-term care planning, and what I hear from a lot of my clients is, well, I think it's too expensive. It is expensive in many cases, meaning that the month-to-month cost of an insurance policy like that can be significant, but generally speaking, the costs that you invest in a policy like that are nothing compared with the actual cost of nursing home or assisted living level care at a rate of anywhere from $6,000 to $7,000 to $8,000 per month if we're talking about skilled nursing care. So the final way to pay for care, remember there's private pay, there's long-term care insurance, and then there are public benefits. In the state of Georgia, we're typically talking about Medicaid and sometimes VA aid and attendance, which is a long-term care for the benefit of combat veterans and their surviving spouses. It's a fixed benefit. It can usually help pay anywhere from around $1,000 to $2,000 per month to help pay for the cost of care. But what most families are really looking for when we get to nursing home level care is Medicaid, because Medicaid in the state of Georgia and in most states will pay for what the person who needs the care can't afford to pay with their own income. That's important. Not with kids' income, not with siblings' income, not with a spouse's income, but what a person can pay with his or her own care. If the person's otherwise Medicaid eligible, the state will pay for the difference. And what I mean by that is, let's say you have a loved one with $2,000 a month in Social Security, but the nursing home cost is going to be $8,000 a month. The loved one will pay, usually with the help of a family member. They'll write a check every month or have direct deposit of their Social Security in the amount of $2,000 or so. And then the other $6,000 to reach the $8,000 per month cost is picked up by the state for as long as the person needs that level of care, which is often for the rest of their life. So you can see it's a very valuable benefit. But how do we get there? There are strict rules, financial rules about qualifying for a program like Medicaid. First, a person can't have more than $2,000 in countable resources in their own name. There are some exceptions, meaning there's some assets you can hold without them being counted, quote, against you for the amount of assets you have. But generally speaking, the person who needs care should not have more than $2,000 in cash or cash equivalents, countable resources in their name. In addition to that, there is an income cap, and the income cap in the state of Georgia right now, and in many places around the country, is around $2,500 per month. If you have more than that, you'll need a special kind of a trust called a Qualified Income Trust, or QIT, and that is a way, at least in the state of Georgia and in many other states, to take care of the income problem. It's a time-tested strategy. It works very well. in states where the Medicaid officials allow it to be used. So usually someone doesn't have to worry too much about having a bit more than the income cap would allow, but the assets are a different story. We've got a plan for those. If we don't, what happens is the family winds up using those assets for private pay, and we can wind up eating through mom or dad's legacy, right? Eating through the savings that they've worked so hard to set aside over all these years. They've been hardworking, they've been diligent, they've been frugal, and especially if we have a surviving spouse or a non-Medicaid spouse, it can be a real problem for that person. We can wind up impoverishing not only the person who needs the Medicaid help, but their spouse. And that's not what anyone wants for their spouse. If the person does not have a spouse, usually what we hear from those people is that they've worked long and hard, not for all those assets to go to the nursing home, but for the assets to provide a head start or legacy for their children, their grandchildren, and other important members of their friends and family group. So to the extent we can do the planning ahead of time, we can often save anywhere from 100% if we do a very effective pre-planning, usually 5 years or more out from the need for care, or even if we have to do crisis planning, meaning mom or dad needs help, the adult children come in and say within 30 days, mom's going into a nursing home, she's probably going to be there indefinitely, what can we do? In situations like that, it's not ideal planning circumstances like it would be 5 years out from the need for care, but there are strategies we can use to preserve typically somewhere from around 50%, anywhere from 40 to 60% of the hard-earned assets that mom and dad have in order to use those for supporting family members that need support or leaving a legacy if that's what mom or dad want to do, or simply for using those assets to pay for what the government won't pay for through Medicaid and make that person's life better. So whereas with estate planning, we're looking at what happens if a person becomes temporarily or permanently incapacitated and what happens when they pass away, where did their assets go? We can address that with many different strategies. A lot of people start with a will or a trust and a power of attorney and a healthcare directive, but in the area of Medicaid planning, elder law planning, helping families find a way to pay for long-term care, what we're talking about in a situation like that is often a more complex part of planning that's layered on top of the basic estate planning. And the effect of it, if it's done right, is to save usually anywhere from 40 to 60%, or in some cases 100% of mom and dad's hard-earned assets. So that's the difference in focus between estate planning and elder law planning. Thanks for joining me today, and come back and let us know what you think of the video and let us know of other topics that you might want us to cover. Thanks very much.